Right to Work is back to being fully instituted in West Virginia. Next on your Labor Minutes. Hello, I'm Mark Harrison. In a 3-2 decision, the state Supreme Court of West Virginia ruled against unions who had brought suit last year to stop the immediate implementation of right to work legislation, saying the unions had failed to show a likelihood of success in challenging the law's constitutionality. The state AFL-CIO and several other unions had argued that the right to work law would illegally take assets from the unions since they still have to represent all employees in a union shop, including those members, which the law would allow to opt out of paying their dues. The plaintiffs further argued that the law violated their rights to freedom of association and their liberty interests. The ruling overturned the preliminary injunction by Kewanna County Circuit Judge Jennifer Bailey, who stopped right to work from going into effect until legal questions were resolved, saying its enforcement could cause irreparable harm to unions and workers. Supreme Court Justice Menace Ketchum, who wrote the prevailing decision of the court, reasoned that similar laws have been enacted in 27 states and that over the past 70 years, none of those states' right to work laws have been struck down in the courts. The law was originally passed in 2016 by the state's legislature majority Republicans, who gave the usual argument for passing the legislation, which was sure to weaken and bankrupt unions, and that was that right to work would be good for attracting new business to the state and give workers freedom of choice, while Democrats accused them of passing the measure for the sole political purpose of weakening unions, and that, as we've seen time and time again in states that adopt right to work legislation, wages will fall. I'm Mark Harrison with your Labor Minute.